conversation can continue.
Okay, actually, the next step is to determine whether or not Mr. Arras' sign is in conflict with the regulation, and to decide whether or not to apply for a notice of possible violation.
I think we are to listen to his testimony as to why it may not be in violation.
Right.
And
I would appreciate that. First of all, I don't know how this all came about. On August 18th, land use received a complaint from a Judy Breer on a sign I currently have on my front lawn. And the only way I know about this is because on the 28th of September, I hand-delivered to the town offices an FOI request for any complaints against that sign. Prior to that, there's nothing. So this has been sat on since August 18th, and since I, on the 28th, handed in an FOI, now it's being acted upon by the zoning enforcement officer, which I find more than a little bit curious the way that's come on.
Now, let me interrupt you on that, if I may. The zoning enforcement officer is a part-time official. She has 25 hours of time she offers or is paid for by the town. Originally, the position was a full-time position. It has been, for the past few years, relegated to a part-time position. Yours is one matter out of many that she has to pursue. So the only thing I can tell you, it's a matter of time. It's not a matter of
I find that incredulous in that we have a 25-hour-per-week zoning enforcement officer. This is the second one in that chain. And here, how many people have you gone out and gone to twice because of violations?
I have no idea.
And that's what, you know, the coincidence just isn't there, and I'm not buying it.
Well, that's your opinion, and I can assure you that nobody in the land use office or on this commission is persecuting you individually.
Okay, I'd like to do what you wouldn't let Ron do, and I'd like to read Halloran and Sage letter. It's dated November 9th, 2010.
To whom?
It's to Catherine Hedsett, town planner.
Again, I have to say that is under privilege, attorney-client privilege, and that's...
You've got it in response to an FOI request.
All right, that then I have no quarrel with, as long as you got it that way.
Dear Catherine, I'm writing to follow up on your inquiry regarding the regulation of political signs by the Woodbury Zoning Commission. I note that political sign is defined in section 7.5.4.0 of the zoning regulations to mean, and, quote, any sign promoting the candidacy of an individual political officer expressing an opinion on a political issue, unquote. I further note that section 7.5.10 of the zoning regulations permits political signs in any zone subject to the following restrictions. One or more signs, total aggregate of signage per property not to exceed 12 square feet. As you can well imagine, governmental regulation of political speech in the form of signs and otherwise is a complicated, dynamic, and sensitive issue. Although there have been numerous state and federal court cases reviewing a wide array of regulatory schemes, there are Connecticut courts would evaluate the federal and state constitutional protections available to such signs. I reviewed some of the more prominent Supreme Court and Federal Circuit and District Court decisions on the subject, as well as a handful of Connecticut cases that touch on these issues. It is a Constitution which may actually be broader than those contained in the First Amendment to the Constitution. There are three fundamental starting points for the analysis of whether political sign regulation would withstand court scrutiny. First, although the government may regulate the time and place and manner of the speech, aka signs, it must be done in a way that is entirely content neutral. In other words, as a general rule, a political sign may not be subject to greater limitations than, for example, commercial signs of any type. Second, even if the regulation is found to be content neutral, it must be as narrowly tailored as possible to satisfy a substantial state interest. In considering this issue, courts have carefully scrutinized whether, for example, time limitations, numerical limitations, and size limitations serve a public interest that outweighs the constitutionally protected right to free speech evidenced by the sign. Finally, even if the regulations have been found to satisfy the preceding requirements, the applicability of the regulations must leave open ample alternative channels for conveying the messages contained in the signs. In summary, regulations applicable to political signs should not be any more restrictive than they are for any other type of sign, and the regulations must serve a demonstrable public interest in the narrowest manner possible. As we discussed, I have reviewed the zoning regulations of many towns in Connecticut in order to see how, if at all, they regulate political signs. A summary containing some examples is attached. Suffice it to say, there is an extremely broad range of approaches, from no specific regulation at all to more detailed and restrictive regulations than those contained in Woodbury's regulations. In addition, the fact that the regulations may be in place does not give any indication of how vigorously various municipalities enforce them. Because of the highly fact-specific inquiry that a court would use to determine whether or not the restrictions contained in your regulations satisfy the criteria necessary to withstand a constitutional challenge, it is impossible to say with any degree of certainty that the particular regulation would pass muster. In particular, you should be mindful of whether the regulations applicable to political signs are any more restrictive than they are to any form of commercial signs or any other type of temporary sign. Turning to Woodbury sign regulations contained in Section 7.5 of the zoning regulations, it appears that there are provisions which permit commercial signs that are larger or more numerous than are applicable to political signs. For example, 7.5.10.c allows signs to be installed in conjunction with construction or repair of property. Although each sign is limited to 4 square feet, there is no limit on the number of contractor signs that may be placed on a particular property. As an additional example, Section 7.5.11.e contemplates principal business signs of 15 square feet and additional signs of not more than 3 square feet each. Section 7.5.12.f, G, and H provide for even larger signs. There are probably other instances where commercial signs larger than an aggregate of 12 square feet are permitted under zoning regulations. Because the restrictions on political signs contained in Section 7.5.10i are greater than those applicable to commercial signs, I believe there is significant risk that those restrictions will be found to constitute an unconstitutional restriction on free speech. If the Zoning Commission is contemplating undertaking a review and revision of its sign regulations generally, it should definitely include the regulation of political signs in the analysis. The desire to avoid the visual assault associated with an overabundance of lawn signs is understandable, but the protections afforded to political speech make it a very complicated and uncertain legal question. Unfortunately, although a regulation may appear to be objective and reasonable in the eyes of the Zoning Commission, it cannot be determined for certain whether or not it is constitutionally permissible unless and until after any court challenges have been resolved. Please feel free to contact me if either you or members of the Zoning Commission have any further questions in this regard or would like to discuss this matter further.